because we're, at less expensive things.
This is working right? Yeah. Why don't we get started? Close. Okay. Why don't we get started, folks? Hi, everyone. We are going to get started on, oh, good. The guest of honor is here. I'm Rachel Rosenblum. I'm on the faculty here, and I'm going to be moderating our panel on Karl's. And so here's how we're going to do this. We have a very brief video from Dick Griffin. It's like 2 minutes long. So we're going to do that first. And then then our panelists will come down. We got 2 here and 1 on Zoom, and I'll introduce them and introduce the panel after the video. But so first we're just going to hear from Dick Griffin, who is a Northeastern class of 1981 and a longtime union lawyer in DC of counsel at Radoff and Kaiser, and former general counsel of the National Labor Relations Board. Jacob is gonna put that up in just a minute, and then Ted and Mackenzie down right after that.
I'm a proud Northeastern Law School graduate, class of 1981. I've spent my entire legal career, now more than 40 years, practicing labor law, and was privileged to serve as the general counsel of the National Labor Relations Board during the second Obama administration. Like so many other Northeastern graduates practicing labor law, I owe my career to Karl Klare's inspirational teaching and writing. In my case, that is literal. At the interview that resulted in my first job, the interview looked at my resume, saw that I attended Northeastern Law School, and his first question was, what did you think of Karl Klare's article in the Minnesota Law Review on the judicial radicalization of the Wagner Act? That question demonstrates the deep impact of Karl's scholarship. It was as a teacher, however, that he truly made his mark. In my era, Karl taught first-year contracts and social theory, and subsequently Labor Law 1, Labor Law 2, and collective bargaining. In each area, he was a deeply learned, unbelievably considerate teacher. In labor law, he conveyed his passion for the National Labor Relations Act and its interpretation, teaching us not just the law, but how it connected to the hopes and aspirations of America's workers. The passion he conveyed has inspired several generations of Northeastern students to enter the field. No single other person in the United States is responsible for inspiring more labor lawyers than Karl. The countless workers and their families whose lives have been bettered through his students' representation are Karl's true legacy. Thanks, Karl, for everything you've done for my colleagues and me. We couldn't have asked for a better teacher, guide, mentor, or friend.
I forgot, I'm so used to wearing a mask these days, I had forgotten I had it on, but now I have it off. I never really had the chance to be Karl's student, but I have had the privilege of being his colleague for the last 13 years. And as many of you know, he's a very generous colleague as well as a very generous teacher. And so I feel very lucky to have had that experience. But we are joined we'll have 3 people with us today who have had much deeper experiences as his students, and I'll be introducing them in a minute. I do want to say, although I was never his student, I did early on in my time at Northeastern, I did join this reading group. There was this sort of informal little reading group where we were going to read some works by Karl Marx and think about their relationship to legal theory. And, it was just sort of a reading group, but really one person in the reading group had thought a lot more about those issues than the rest of us. So lo and behold, Karl's like making little packets of reading assignments for us, and he's like giving us discussion questions. And, so although I wasn't really your student ever, I feel like I got a little taste of the the care and love that you bring to that endeavor. And I do think, I love the title of this event, because I do think love is a big part of it. And I want to give a big thank you to the folks who put this event together. And, you know, Vina Dubal said on the last panel that there's like, you know, this really special sort of feeling in the room. And it's really true. I mean, for me, this is sort of unprecedented in these pandemic times to be in a room this way. We all, I think, at this point have developed a very high threshold for, you know, what event we would go to in person, right? Particularly when it's being live streamed and you could just sit there, you know, in your living room and watch it. And it takes a very special person to get us all out. And so you've given us a gift. You've given us so many gifts, but one of the gifts you've given us, the most recent, is to bring us all together for this kind of event, which is very rare these days. So the folks on this panel span really almost all of Karl's teaching career thus far, from his very first years on the faculty at Northeastern up through the pandemic. And so let me just briefly introduce them. I'm not going to, the full bios you've got, I'm not going to give you the full bios, but I'll give you the quick bios and then turn it over to them. So we have Ted Lieberman, who is Northeastern class of 1978, was a labor lawyer for many years, and more recently has been a documentary photographer. We also have Sukti Dital, who's, can you, here, can we get to, yes, can you, yes, wonderful. Hello, hi Sukti. So Sukti is Northeastern class of 2006, and she is currently the executive director of the Bernstein Institute for Human Rights at NYU Law School. And then we have Mackenzie Spear, who is Northeastern class of 2020, and currently an Equal Justice Works Fellow at the Legal Aid Society in Chicago, working on housing issues. And the way we're gonna do this is, I have a couple of rounds of questions I'm gonna ask. And we're going to kind of go back and forth among them. So they're going to, even though we're going to kind of be going back and forth to the video, everyone's going to stay up here the whole time. And we're going to leave plenty of time for discussion, because I have a feeling there are many people here today who also have experiences as Karl students that they might want to share. So the first question, and we're going to go in chronological order of graduation here. So starting with you, Ted, first impressions of Karl Klare, and how, what effect did Karl have on your time in law school?
Yes, thank you, Rachel. By way of introduction, I came to Northeastern to be a labor lawyer. The mine workers have a song, "Which side are you on?" I was very clear which side I was going to be on. I had come up through the New Left, was very active during college and after, and decided the best way I could do something with my life was work with the institution of labor unions. And so after my first year, I show up for the class in Labor Law 1. No one told us who was going to be teaching it. And we walk in and there's Karl at the front. And he looked eminently presentable and, you know, was very nice and pleasant. And, you know, so the first impression was positive. And I think he, to me, looked a little lost at that point. And I invited him to come out for a cup of coffee. And we found that we had progressive backgrounds in common. As the course started to go on, I found that Karl was teaching a little differently than most of his colleagues here at Northeastern. I think he was the only one that gave us Xeroxed 4 pages of chapter 1 of volume 1 of Das Kapital, so that we would understand the relationship between use value, exchange value, and surplus value. I didn't see that in Cox and Bach. But Karl was not, he did not push any philosophy or theory. He said from the beginning of the class, he was happy to have discussion and argument and opposing views. But he had a good way of raising questions. Let me give you one example. He's teaching duty of fair representation, an important concept in American labor law. So we're reading Ford Motor Company versus Huffman, 345 US 330. Right? And it's a fairly straightforward case. A group of employees who Ford Motor Company, who are in the bargaining unit, are suing the union and management because there's a clause in the contract that said that if you were a veteran of the U.S. Armed Forces or the Merchant Marine during World War II, you would be entitled to company seniority for that time, even if it was before you had become an employee of the company. And they defined the war as commencing after June 21, 1941. And so the question was, did the union breach its duty by giving seniority to people who, in fact, had come to become employees of the company after serving in the armed forces when there were others who had been with the company longer. And the court said, yes, this was fine. They used the words, there's a wide range of reasonableness that's afforded to the union and the company to take care of situations when there are really competing claims and purposes that are being served by certain provisions of the contract. But that made sense. Everyone's fine with that. We understand that. And then Karl asked the question. By the way, anyone know what's the significance of after June 21, 1941? And class is sort of looking around. Well, Pearl Harbor? No, that was December 7th. Henry Ford's birthday, Walter Reuther's birthday. Yeah. And finally it comes out. June 22nd, 1941 was the day that the German army invaded the Soviet Union, notwithstanding the peace pact that they had between the countries. And it was the day that most of the communist parties and leftist parties around the world shifted their line from that the war between France and the UK and Germany was a war between imperialist powers to this was the Great War to defend socialism and the rights and freedom of the Western world. Why was that in the contract of the Ford Motor Company? Because the Communist Party of the US and other leftist parties were very strong in the United Auto Workers at that time, as well as other unions. And they somehow picked that date to start with the seniority as opposed to any other date. not mentioned anywhere in the Supreme Court case, as you might imagine. And it was not a big deal in the course, but I remember it, and it was, I think, a way of one of many ways of Karl reminding us that there's more to these court cases than meets the eye and that are talked about in the cases. Oliver Wendell Holmes once wrote that the lifeblood of the law is not logic, but experience. And to me, in this course, Karl was really saying, and we were learning that experience is not simply the dry facts of the case, but it was also about politics and power and strategy and tactics and cunning. And this would be a theme during, I think, the entire time. And it was a lesson that served me well in my subsequent career.
Thank you, Ted. Let's go to you, Sukti. Tell us about your time as Karl's student here at Northeastern.
Great. Can you all hear me okay?
Yep.
I have my head is probably this gigantic thing on that screen. I am so sad to not be there in person. It was truly, as you said, Rachel, one of those moments where you felt like this was something worth coming out for, and then my partner tested positive. And so here we are, but very, very grateful for technology in this way to be here with all of you. So especially on this panel, because Karl, I can see the back of you, but your spirit and your humility and kindness is always with me. And so to be able to just have the privilege of reflecting on the ways in which you have shaped me and countless other students is a total privilege. So thank you to Lucy and all the other organizers for this gift. In terms of the question of when we first met Karl and how did he shape law school, Karl we were all waiting to take Karl's classes. He was a bit of a legend. He was like a rock star at the law school. We knew he was this world-renowned critical legal theorist, and of course his legacy in labor law. And he was known to just be like a cool human. And so everyone kind of was clamoring to get into his courses and to absorb a little bit of him. And I mean, he was one of the professors that drew me to want to go to law school, and particularly Northeastern. What was just mentioned by Ted, I was nodding my head, because when I think about my experiences at Northeastern, and I think even more poignantly about my time with Karl, was this constant questioning of background rules, that things are not just what you see within the case summaries and within the briefs, but there is a whole political power play happening in the background. And while I thought I understood that even when selecting Northeastern, it wasn't until I became his student and started really excavating some of the decisions that we were reading together that even came more to life. And now, my gosh, 15 years later or 16 years later, I see it even more clearly. So I was fortunate enough my third year, so it was the spring of 2006, to be in two classes with Karl. So it was like a buy one, get one free, waited 3 years and got critical legal theory and employment law together, both of which have shaped my, not only my law school, but really my trajectory in the course of my work, both in human rights and also in labor law and labor rights. But what I remember very, very intimately is the feeling of critical legal theory. It was a seminar, so it was only, and I think it was maybe like 12 or 14 of us in a small room. And I just remember the feeling of that. I'll never forget the feeling of that room. It was safe. There was curiosity. There was humility. we didn't kind of come with egos or titles. And I think I really learned from Karl how you model that practice. And when you model a certain way of being, that naturally gets absorbed in the energy in the room. And that's how it felt when we walked into that room, I think twice a week for an hour and a half. It was a really grounding community. And Karl was able to create a space for us to not only reflect on some of the decisions we were reading and some of the law review articles, but also to think critically about what might be possible, to not be so locked into this notion that law was fixed and that these systems were fixed. And so in that, we read excerpts from Nelson Mandela's Long Walk to Freedom and a number of South African Constitutional Court decisions. And through that process, there was a probing by Karl as a professor, but it was done gently. And it was done, again, with this sense of humility and kindness and an appreciation that even though we didn't have decades of legal expertise and we were not, labor rock stars, we mattered. And our role was a really powerful one that we would eventually play in this project that is the legal ecosystem. And I think Karl always saw that, even though we didn't necessarily see it for ourselves. And one of the things I remember a lot about that class that sits with me is while we were learning about Mandela in particular, this notion of what it means to be inside and outside of systems. What does it look like to practice law, to practice in a system that is built for to silence, to oppress, to marginalize, to serve as a weapon of marginalization, and yet still Mandela engages in that and also supports outside movements. And so think really, really creatively about how we could take this tool that we were gaining and be able to build and work together to build a more just future that I think all of us were really sharing at that time. So with that, I remember it was the first time I'd actually been introduced to the concept of Ubuntu and this notion of interdependence. And that has stayed with me. I never understood how powerful it was and how I was really motivated as my animating principle, this notion that I am because you are. And it was in Karl's course that I really started to think about that. And at graduation that year, I remember speaking about the power of Ubuntu and the privilege and responsibility that we as attorneys carry in interpreting words. And what does it mean to be one who works through the work of translation and presentation? And there was other concepts that I really didn't understand. I didn't understand horizontal application. I'm sorry, Karl. I didn't fully understand how animist property was until, years later. But those seeds were planted, those seeds of kind of understanding the power of background rules, who gets to be in a room to speak, who doesn't, what does it mean to engage in a system that is fundamentally unjust, if your desire is to create a more just system and redistribute the privilege and power that you may have for the greater good. And these are concepts that have stayed with me and continue to stay with me many, many years later. And I would just end by saying on this point that, really marked by the critical legal theory course, a couple of years later, I took a solo trip to South Africa to really retrace or pretend to retrace some of Mandela's major footsteps. And it was that book in my hand, that was a very big book to travel with, but to take Long Walk to Freedom throughout South Africa and just learn by doing. And so I want to thank you, Karl. I didn't realize it then, but that was really the beginning of a lifelong career in human rights and particularly grassroots justice, and also a lifelong friendship. So thank you, and excited to be here.
I think let's try to hold applause, I think, till the end, just because we're going to try to go back and forth and sort of have this be a conversation. And but we will have a chance to applaud all of you at the end.
Well, thank you for having me. I'm honored to be here, Karl, and everyone else who invited me. I think, well, the first time I saw Karl was when he walked into a room in the downstairs to talk to us about the Northeastern Charter and how we were going to be involved in the school. And when we were talking about our first meetings with Karl, I thought about how he always encouraged us to be kind of participants in the law school in learning and not consumers of this education. So the first time he walked into Doxer, set down this charter and really asked us to step up and be part of the governance of this school. So I think in the same way folks have talked about in theory, how he asks us to build more participatory systems. He was also doing that every day here. As soon as we walked in the door the first day, said, you're an important part of this. You're a participant in your education here. So of course, then he also always volunteers to give a lecture for the National Lawyers Guild every year. And I went to that and he asked questions that no other professors in my first year were asking me. I think we did a simple torts case about a car crash. And something I remember both about that lecture and his labor law class is watching him walk a group of people to a binary conclusion and then just blowing it up for everyone. So it would, we'd walk together on this logical conclusion that the judge got to, and then he'd ask a question like Ted said, well, what is the state? Or what role does insurance play in this system where we have a car crash? And what would that mean for the disability rights community if this was insurance was the solution to this supposed binary conflict between the person who caused an accident because of a medical emergency and the person who was the victim of that accident. So even though I had no intention of going into labor, I signed up for Labor One. I got to watch that again and again, Karl walking us to a conclusion and then offering us midway through the class something that would, cause a kerfuffle and everyone would have to deal with it. And I enjoyed those classes so much because it was rigorous. One of the hardest exams I've ever taken was Labor One. And Karl would do all the scaffolding we needed to get the law. And then he would invite us to actually think about what was happening in context. And for me, that gave me the opportunity to do all the learning that I wanted to do at law school. And instead of talking after class about, the criminal legal system and what's actually happening with my peers, I got to bring that conversation into class. What does labor law mean in the context of work, in the context of working people in this country? And it went from being a debrief with my friends after class to something that was given space in the classroom. So in that way, I felt like Karl took us seriously as learners. He took movement seriously as part of what we were engaging with when we were talking about the law and lawyering. And even though I don't do labor law and I'm not an academic, I use that every day in my practice now, which we'll have an opportunity to talk about later. The real gift that Karl gave me, though, was American legal thought. We started that class right before the pandemic, and it was a small seminar class where Karl has meticulously cut out sections of law, but also of theory. And we talked about, England in the 1700s, and we talked about what's happening today. And he managed to create this puzzle that fit together into actually thinking about what we were going to be participating in when we left the law school. And in March of 2020, that project suddenly shut down, and we went online. And if anyone, most people here have probably had interactions with Karl and know how important an individual conversation with Karl is, having time to walk in the hallway with him, or, we lost all of that all of a sudden. So we had the opportunity then to start meeting with Karl weekly, a group of us, and just to see how he was doing. He'd check in on us, and we've talked every week since the the shutdown in March. Again, he takes us seriously as a group of newer attorneys who came to Northeastern with work experience, with different identities, and wanted to hold those throughout. And I think Karl's classroom allowed us to do that, allowed me to do that. And he respected the work that I'd done before I got to Northeastern in a way that sometimes felt erased. And then he took us seriously as a group of young people who wanted to do not necessarily academic work or labor law, but wanted to practice and have rigor to our practice, but be day-to-day lawyers, most of us in legal services. So I think, Karl, you created a space where you allowed us to do the learning that we wanted to take out into the world, and you didn't see that as less important than the work that was happening in the academy. And I'm very grateful for that.
I'm not going to police your clapping, I decided. But wait, before we go on to the next question, I just have to ask you a follow-up question, Ted. Am I right that when you encountered Karl in the classroom, that was his first week teaching?
That was his first day teaching law school, although if I remember correctly, and I may not, Karl was doing some teaching before he even went to law school. Yes. Karl clearly showed a practiced, I don't want to say patter, but an easy way speaking to a large group of people. But this was his trial by fire in law. And we liked it, and he obviously liked it as well, because very shortly after that class, I had the privilege of being a co-op. I was a co-op clerk at Siegel Reutemann, where he was still an associate. Thank you. And we talked a lot then, and I was interested in being an associate in a law firm like that, and he, by contrast, was interested in being a legal professor at a law school like this. I'd like to say we traded places, but we didn't. But I felt like my experience with Karl had prepared me well for a career in a labor law firm.
Right, there you have it, Karl's first day of law teaching. And so, Mackenzie, you alluded to this a little bit of sort of what I know it's a shorter period of time post law school for you than for some others. So actually, maybe we'll start with you. We'll go maybe in reverse order this time around. And so, how has Karl shaped your time since law school, either in the sense of sort of an ongoing relationship, or sort of what you learned, and how does it affect what you've done since? That's a question for everybody.
So I am an eviction defense attorney in Chicago, and I mostly work with people who are living in subsidized housing. So if you are evicted, you also lose a federal subsidy. So a government benefit that helps you pay for your housing. And you can explain, I can say I do eviction defense, but I think a way that Karl might talk about it is I'm on the front lines of when it's moral to remove someone from their home. So we talked about that a lot in American legal thought. The idea that law is in some ways a marker of what is moral or right. And so when I think about my clients and how the law thinks about when it's moral for someone to be removed from their own home, that's why I go to work every day. This idea also helps me conceptualize how to talk to my clients about power and the courts. So if I can understand that maybe my client doesn't agree with the law's idea of when it's moral to remove them from their own home, and I disagree with how the law thinks about that, I can meet them where they're at a lot quicker, right? I can say to them, this isn't fair, but this is how the judge is going to think about it. And that's why we need to make a plan based on how this is going to go. That tool for me crosses identity. Most of my clients are Black women. I'm a white woman who's highly educated. And I can cross that boundary really quickly by saying, I don't think this is fair. And our court system isn't necessarily fair, while still acknowledging the power that law and the courts have. So I think in a roundabout way, American legal thought has given me tools to kind of be rigorous about the idea that the court system and laws are moral judgments, but they're not necessarily ones that we share, and they can be contested. Another thing that comes up in my work a lot is just the kind of binary thinking that happens in my own office. So I find some of what folks were talking about earlier with the transformational constitutionalism, the idea that this is all kind of contested and it's a discourse, and we need to be using language and ideas all the time through the law to make change. I feel like in my legal services office, there's often a discussion of this is the way the law is and this is the way the law isn't. So a lot of the work that I do to bring that idea out into the world is through my case acceptance meetings, saying, I think there's actually room to move this. I think there's a reasonable interpretation that this protection could be applied to this situation. So I'll give a quick example, which is there's a law passed in Cook County. It's called the Just Housing Amendment. And it says that you can't discriminate against someone in a housing decision because of their criminal history, so arrests and convictions. And the regulatory body that's in charge of enforcing that has mostly thought of it as you can't deny someone's rental application because of an arrest or a conviction. They've issued a lot of guidance about that. It's really thought of as like a front end entry to housing opportunities. I've been using that in eviction court to say you can't evict someone because they've been arrested. So a lot of times in subsidized housing, all these background things are happening where the Chicago Police Department reports arrests at subsidized address to the property owner. So if you're in subsidized housing, you're more likely to have a notice of termination for an arrest that comes up. So why are they allowed to make a decision based on an arrest record to remove you from your home? And so reasonably, you can interpret you can't make a housing decision based on an arrest or a conviction to also mean you can't evict someone for that. There's a lot of folks in Chicago, even in my world, who are on the tenant side who say, well, this was all about entry into housing. This was about application. That's why this was created. But if you use it in court, you talk to the right judge about it, you get a good ruling, and you build that out. So there's nothing that says we can't be doing that. And so I think that's part of what Karl is talking about, is that we have all these small experiments where we're pushing to make the world more just with tools that maybe folks didn't think were supposed to be that broad or that revolutionary or forward thinking, but can really be powerful. I also want to say about the Just Housing Amendment that this was an organizing effort by formerly incarcerated people to build this into Cook County law. So it came from the movement. And I feel like one of the things that I learned from Karl's classes is because we're lawyers, we have to think about and be responsible for the arguments we're making. And I feel like one of the things I can be proud of is moving with the people who passed the Just Housing Amendment to try and expand their vision of what's fair in Cook County. So taking what they built, which is a powerful tool, and trying to be a part of enforcing that. The other thing I think I want to note about how my work is influenced by Karl's kind of teaching is how I process my role as a new attorney. I've only been practicing for 1.5 years. And I work in what I will fondly and not fondly say is like the Wild West of courts in Cook County. I work in eviction court. It's a summary proceeding, cases fly quickly. And I think I could internalize a lot of the losses and a lot of the, my clients are already up against it. They're up against bias. They're up against the structures that have been created to make it easier to evict someone than it is to file a claim for conditions issues. So when I go to court, knowing that gives me the context that I need to keep showing up even through the small and the big losses. And to think about separating my reflections about what I need to learn and grow in from getting a no from a judge. And so I think it's been a powerful tool for me to be able to feel resilient, but also feel like there's a lot that I need to keep learning and I want to build those skills. But it doesn't necessarily mean that I'm going to win every time or the right argument is the winning argument. And that will carry me a lot longer way than feeling like if I don't win, I should sit down and not try that argument again.
Thank you, Mackenzie. Sukti, why don't we go to you? So what effect has Karl had on you in the time since you graduated?
I feel like I could go for like 10 hours, so this one's going to be hard. I also just want to state that I have a 3-year-old sleeping upstairs and I'm praying to anything that's auspicious that she won't wake up. But if she does, you might see me zoom off and zoom back in, but hopefully not. What I think about is the month of April. And the month of April, which is what we're in now, has proven, as I was thinking about this question, to be a pretty auspicious month for my histories with Karl and Lucy. It was in 2010, April, that Karl and Lucy were at an alumni event in New York City. And I had just come back for a few months having worked. I was working in India. You heard this morning from Jayshree Satpute in the first panel. She's a very dear friend and someone I've worked with for a number of years. And we were both working at a local human rights organization at the time. And we were doing a ton of social and economic rights litigation on issues of housing and health. And when I was back in the States for a little bit, I ran to this event because again, Lucy and Karl are still the rock stars. And so I thought, oh, I can see them in person. This will be so wonderful. Little did I know that since the time I had graduated in 2006 to 2010, that ISERP, the International Social and Economic Rights Project, had been established by Lucy and Karl. And they didn't know that I was engaging in social and economic rights litigation in India. There was some time for which we were not in touch. And so I remember being at this bar on the Upper West Side, and it was one of those, again, auspicious moments of sliding doors where it was like, we were at the right place at the right time. And I learned that in 2 weeks' time, they were going to be having the second convening for ISERP in Bogota. And my colleague from that Indian Human Rights Organization was going to be attending. And it was just this beautiful synergy. And in the classic way that Lucy and Karl managed to make things happen, in 2 weeks, I was on a flight to Bogota to serve as a rapporteur for this convening. And that was, again, another marker. It was an opportunity to be encased in and part of a larger global community of advocates and academics and judges who were thinking very, very critically about what it meant to advance social and economic rights, and to do so in a way that tried to disrupt the silos that are often calcify when we get into the legal space, where the academics speak to the academics and the practitioners speak to the practitioners, and the judges, I don't know who you speak to, but the judges are with, their own community. And so you find yourself not being able to have that cross-learning. And ISERP really, really strives to disrupt that way of being and doing. And it's been more than a decade now of being a part of this really special community that is stewarded by Karl and Lucy. And it was through this work that after a few years of continuing to work at that local human rights organization that Jayshree and I and another women human rights defender started to really feel this sense that our approach, this glorified kind of public interest litigation, this opportunity that India had, this very expressive constitution, we were litigating cases around abortion and maternal death and eviction, and we were getting these victories in the courts. And yet, as Jayshree mentioned, we would go back into those communities and we would see so little changed in the material lives of people. And it was this real sense of, what are we doing wrong? What are we not doing? Who is not part of this conversation? Who are we failing to listen to? And how can we better leverage our privilege and power as attorneys to create a different way of doing? And it was a lot of conversations with Karl and with Lucy and with the ICERP folks to really think about, could we imagine and dream of an organization that might in a small way be able to address some of those gaps? And our first presentation as a group, kind of launching the idea of Nazdik, was with Lucy and Karl sitting in the front, just like I see the back of their heads, but if I was sitting up there today, it would be the same thing. I'd be looking at them. And we created this, what we thought was a very snazzy presentation. And I would be mortified to go back and look at that presentation now. But, we introduced this idea, and it was that sense of, we appreciate you, we see you, you are learning with us. We will share the knowledge that we have to kind of guide and advise you in this process. But it was 100,000% do it. Like, we're with you. And that sense of accompaniment is such a gift. And had it not been for Karl, and had it not been for Lucy and others to kind of stand with us, I really think that we wouldn't have felt the kind of confidence to be able to go forward in the ways that we did with the organization. And again, I think it was April or March of 2016, Lucy and Karl came to India with other ICERP members, and we hosted a convening in Delhi. And it was so special to be able to take this community into one of the communities that we are working in. They're local artisans. It's called Katputli, which is these wooden. They work with wooden puppets, and they are indigenous to Rajasthan, but have been living in this informal settlement in a very expensive part of Delhi for a long time, and they are constantly under the threat of eviction. And it was in conversation with the ICERP group and with our communities, and being able to see how this organization that we had built, that was really centered on, again, disrupting silos between who gets to speak, who gets to engage, what does it mean to be a community engaged in your own justice struggle. And all of that felt like it was coming together in that way that we were thinking about in critical legal theory, about inside and outside activism and background rules, and dreaming of different ways of trying to do this work. And so I will never forget that collision. And it has really stayed with me for many, many years. And since then, I have moved back to the States and am now working at NYU at a center whose focus is really around democratization of law, and this idea that we should be thinking again very critically as attorneys and those in the legal profession about, how do we step aside? What does allyship mean? What does it mean to redistribute legal power and create an opportunity for those impacted to engage? And so all of these moments have kind of built on each other. And so I am so deeply indebted to Karl for his accompaniment and vision and support. And Karl, you are such a supporter of Nazdik. So quietly, every year, every few months, you bring us into these conversations and conferences, and I cannot express enough how much that means to all of us. And I will just end with one personal story. That in 2015, again, it was April, my partner and I at the time, my fiance at the time, were putting together. We were planning a wedding from India in the States, and it was my partner's an atheist and I'm more spiritual, so we were going to have we weren't going to have a religious ceremony, and we wanted to have one that was really rooted in the senses, and so earth and fire and water and air. And we thought of who would we want to officiate, and we thought, and it didn't take very long. And I turned to Vivek and I said, well, what about Karl? And he was like, Karl, your professor? And I was like, yeah, and my friend, the one that we go to ISERP, and he's just this legend, and he was part of transformative constitutionalism. And my partner is also a human rights advocate, and it was a no-brainer. And so in April, I think 20th, I sent you an email, Karl, and I was like, will you officiate our wedding? And you generously said yes. And I'm sure you didn't sign up for all of that. Little did you know in 2006 you'd be officiating a wedding, but here we are. And you did it beautifully. And you were there witnessing at one of the most important moments of my life. So thank you. And here it's April again. So I do think there's something about April and Karl. And so thank you again, Karl, for just being such a wonderful friend through all of these twists and turns.
I just want to say Suchi sent a wonderful picture from her wedding, and actually Mackenzie sent a screenshot of the Zoom group, and we didn't quite get our act together to put them on the screen, but I think we should. I just want to encourage people to go dig out your pictures, Karl, from various stages of life. I think we should do something with them. I don't know what we're going to do, but you're all on notice here. Go to your archives and try to find them. We'll send out an email about it or something. So Ted.
Thank you. I have to say, I feel somewhat envious of my two colleagues on this panel who got to experience Karl's teaching and friendship at different times and in courses and in issues beyond just labor law, where Karl had been able to think more about these issues in a general way and in the context of torts and contracts and constitutional law, and not just limited to labor. So I feel like they got to experience all 9 of Beethoven's symphonies, and I heard one of the early overtures. And it was a good overture, and I appreciate it. I feel like I should really go back and listen to all the. I also think I need to mention that as influential as and important as Karl's teaching and friendship has been to me, that there were other professors at Northeastern who were also extremely helpful and important to me. And I'm thinking particularly of Dan Gavelber, who was here earlier, Steve Subrin, and Judy Brown, who hopefully is watching the live stream or will watch the video later. But the 4 of them can be thought of the 4 horsemen and women of the apocalypse, and help make me who I am. That's unfair to put it on them, but in terms of sort of this meta, how Karl influenced my life, I think I would have given different answers at different times, and I think Karl would always say that you have to understand a phenomenon or an idea or an institution, and in the particular time and context that you're dealing with. We're all at a time when We see a horrifying war in the Ukraine. We see a global pandemic that has killed tens of millions of people, including 1 million Americans, hundreds of thousands of which could have been prevented if we had had competent leadership in our country. And we are dealing with, possibly for the first time in many, many years, the rise of effective assaults on democracy and basic human freedom in our country, as well as other Western countries. And it made me think that, you know, the last refuge of a lawyer is to quote somebody else and then cite it as precedent. And so what I thought about in terms of Karl was the poem by W.H. Auden entitled September 1, 1939. That date, by the way, you might remember, is the actual date of the start of World War II, not June 22nd, 1941. But the poem is about the despair of the start of the war and all the woes of the Western world. But at the very end of the poem, Auden writes the following: defenseless under the night, our world in stupor lies, yet dotted everywhere, ironic points of light flash out wherever the just exchange their messages. May I, composed like them of eros and of dust, beleaguered by the same negation and despair, show an affirming flame. When I think of Karl, it's not just that he was a good teacher or a great teacher or a good scholar or a great scholar, but in all of his endeavors, in his support for students, in his support for social justice, and in his generosity of spirit, then and since, he has shown himself to be one of the just of our era. And as despairing as we may now be, his example encouraged us all to show our affirming flames. Thank you, Karl.
So I'm going to give you three a chance. If there's anything that you sort of thought of when someone else was talking, or that you want to ask each other or anything before we open it up to the audience. Does anybody have anything they want to add or say or ask? Open it up. Okay. Let's open it up. What do you all have to say? I'm sure there's a bunch of other former students of Karl's in the audience here. You don't, if you can talk loudly, you don't strictly need this. The mics will pick you up on Zoom. Anyway. Yes.
Hello, Ryan Quinn. I'm class of 2019. I'm an associate at Siegel right now. We're so proud of our link with Karl there. I wanted to say, I could say dozens of stories about Karl, but I will try not to. I just want to mention two things. One is that in his labor law textbook, something I've never seen before in a textbook in 20 years of school, which is there would be a story about something that workers did, and then a sentence that says, please take a moment and think about the courage that it took to do this. And I think that first, everybody did. Everybody did, in fact, take a moment and think about that, even though they had hundreds of pages to read for other classes. And I think that that is such, to me, it's the perfect example of how Karl teaches and how he connects what you're learning with what the actual stakes are. And I did always love that when I'd come across that sentence in a book. that he had written for Labor Law 1 or 2. The other thing I wanted to say is Ted mentioned Ford Motor Company versus Huffman. And I recall another lesson that Karl imparted in 2018 that also is sort of the classic Karl teaching style. I think we were discussing the duty of fair representation, and probably every labor lawyer who's ever dealt with a DFR case has quoted the language Ted quoted and has said something, there's a line about the complete satisfaction of all is not to be expected. That's in every brief that's ever been written since 1953 on the issue. But after we went through that, Karl then wanted to get to the stakes of what was being discussed. And so there's Mr. Huffman, who I guess had not been in the service and did not have his seniority, but those aren't really the stakes. And through a very effective use of a series of questions, he got us to the point of realizing the stakes of this case are that none of the women who are working in the plants have any seniority. And that's what the case is about. It's not mentioned at all. But of course, there were, the unions win and good, and every lawyer is going to cite that language. But I can't cite that language without thinking, am I doing the right thing? Even though, unions my clients, and obviously they're right, they're never wrong. But, is this the right thing? And that's, I don't know, that was the gift of taking Labor Law 2 with Karl. Thank you, Karl.
Thank you. Others? Don't be shy.
Maybe I'll jump in just as we're waiting.
Yeah.
I think it was someone talked about the student charter, and it just gave me just wonderful flashbacks to when we were a student and thinking about, I think, Karl, one of the things that I really I appreciated from you is how much care and intentionality you have put towards how Northeastern Law School has structured itself, the ways in which we think about participation and representation in the way in which the law school functions, and that sense of pride that you have shared with all of us about your time at Northeastern and the way in which that scaffolding and infrastructure so deeply connects to the spirit and the being of an institution. And it always felt a safe place to go to your office when it felt like some of the aspects of the law school were changing, and some of the spirit of its attempts to be egalitarian and its attempts for participation were naturally being challenged. And to feel as if it was not only like a place of present space, but you would give us that historical context about how we came to be. And I think that I just really, really valued that so much as a student, and think very critically about it now when developing kind of collective documents and collective agreements, because that practice of co-creation, that process, irrespective of if it gets enforced and irrespective of what may come, that process of collaborative creation is just so powerful. And so I just want to, I chuckled when I heard the student charter because I know how passionate you are about it, but I also understand why you are so passionate about it. So I just wanted to just add a comment about that.
I say he shows up at faculty meetings waving the the charter as well. I think he carries it around in his pocket all the time. Pat.
I just wanted to say that I suddenly started counting up the years I have known Karl, or known of Karl, because I think I knew Karl before he before we became colleagues, well before we became colleagues, because I was in Karl's law school class. I mean, we were actually in the same section. And at that time, for any of you who've seen the movie The Paper Chase, it was filmed while we were in law school. So it was like big amphitheaters with hundreds of people and a professor who stood at the top of the class and yelled at you. Or actually in those days, women were 8% of the entire class. And I think ours was the last class that had powder puff days, where they would actually throw powder puff questions at the women. They would call on you once a month, and it was just, there were very few people I remember from my law school years. The reason I remember Karl is that he was so respectful, but he pushed back. He created a space for his beliefs, and for those of us who had beliefs that, throwing powder puffs at us was not the appropriate thing, or throwing chalk at us was not the appropriate way to handle students. So even as a student, Karl was an activist, and as a student, he was also a teacher. And so I count myself among his students to this day.
So I'm Dick Griffin, class of 81, and I've known Karl for a long time. And we've had a series of conversations over the last 40 years where we've identified stress points at the law school, where we recognize that when I arrived, and for many, many, many years after, I hope it is still the case today, we were the #1 public interest law school. It's true. But there was tension as to what direction the school was going to go. And would we be just another pretty good law school? Or would we inspire and celebrate the kind of passion that you've heard about from these panelists and from others about, and would we be creating lawyers who would leverage their abilities to improve the world, improve the environment, improve the condition of labor? And Karl consistently helped me and others when we talked to him about what do we do, what's happening at this law school, how to think about it in the context and in the moment it was in. And I think to the extent that we continue to be a law school that decisions and to decide when to push and when to wait, and the wheel is still in spin, obviously, but he's helped to guide it. I think he's helped to guide the law school to stay in a good direction.
Hi, I'm Sarah Heidemann, class of 2016. And I came to law school here because of the labor law program. Emily called me, and I don't know if Emily's still in the room. Emily's there. And one of the things she sold me on was Karl, although I knew Karl about you before, long before that call. And the story that I want to relay, so right after law school, I took a job at a labor law firm, and one of the first questions that I got asked at that firm was, would I be willing to defend a union, even if I thought they were wrong, or even if, I thought the individual worker was right. And then about a year later, I started working at a national legal civil rights organization where I still work. And one of the first questions upon wanting to work with unions at that civil rights organization I got asked was around, would I be willing to back an individual worker within a union context, if they were going against their union, if we were to co-counsel something together. And so I pretty quickly realized that there was this gulf that, I hadn't had to experience in my learning about labor and then employment law, that a lot of practitioners saw as a tension between kind of the individual and collective power. And so, I very quickly realized that what I needed to do was fly Karl down to DC to give a presentation in front of my entire office for all of my colleagues about Labor Law 101, so they could see that collective power was something that we could also use in our civil rights work in the context of union work, but more specifically that we needed to really erase the gap between the ways that workers were using the law to gain power in a broader sense. And I have to say that that talk has had a lasting effect on my colleagues and has opened up new pathways for us to be able to engage with the labor movement in a more robust way over the past almost 5 years now that I've been at the organization. And I never saw the individual and the collective as so in tension because of the way that, you know, I learned the law here, both Lucy, your classes as well. So thank you for that, Karl, and thank you for helping the civil rights movement of DC, the civil rights legal organizations in DC understand why working with unions is absolutely essential and important. Rachel, your admin class has also been very useful.
Anyone else? Yes.
So I'm actually not a former student, I'm a current student. I'm a 3L here. And I'm in one of Karl's classes right now, and I also took Labor 1 in the fall. And there are about a million things I could say about his teaching, but I think the story I want to tell is one of the first days of Labor 1, because my dad actually also went to Northeastern Law. I should remember the year he graduated, but I don't. Sometime in the early 80s, and actually had Karl for contracts. And, you know, naturally, Karl didn't remember him. Of course, I didn't expect him to because it was a big class a long time ago. But I just came up to him after class one day, and one of the very first interactions I'd ever had with him and said, hey, just a fun fact. My dad came here and he had you for contracts. And the next day, Karl came and he had gone through and found his old class roster and printed off my dad's photo to show to me. And I think the reason that sticks with me so much, I mean, it just made my day, the day it happened, but the reason that sticks with me so much is I've heard so much about Karl before, but that's really what confirmed for me that, you know, the unique relationship he cultivates with students. You know, that small interaction just really showed for me that he listens to his students, he talks to his students, he wants to be friends with his students. And that was something that was really, it has stuck with me since it happened. So Karl, I count myself among the lucky many that have learned from you. So I just wanted to tell that small story from Labor 1 last fall.
So I want to follow up on Ted. I want to ask you a question. So, because you know, I think one recurring theme is people coming to Northeastern partly because Karl's here or knowing he's here. He's a legend, as Sufti said, right? Can't wait to get into American legal thought. But so you got him on his very first year here, but am I correct that you actually did know of him before you got here? Would you tell that story?
Know him is too strong a term. When I was a freshman at Trinity College in 1968, I was working with the anti-war people there, and I was drawing posters for an anti-war demonstration. And one of the featured speakers was Karl Klare, Yale SDS, I think. And I spelled Karl wrong, you know, C. Who could imagine it would be KK? And I still have that poster somewhere. But I never met him then. A few years later, when I was working in Washington, I met his brother, Michael, who at that time was a well-known, well-regarded writer and researcher on US policy and imperialism in Latin America. But I had no idea that I would later meet Karl and that he would teach me the fundamentals of labor law.
Thank you. So Karl, your reputation always precedes you. So we have about 15 minutes left. Do you want to get in?
Yeah, I want to say one thing. Many of you know that Karl and I are very dear friends, and that we hang out together a lot. I'm sitting here and I'm seeing his head just get bigger and bigger right now. So I want to deflate for just a moment. I hang out in his office a fair amount, and Karl complains sometimes. And one of the things he complains about sometimes is how much work he has to do, how overwhelmed he is about how much work he has. And so every now and then, because I'm a very good friend of his, I try to say, Karl, don't do this. You don't have to do this. You don't have to do this. Now, those of you who have been his students know he is a master of making charts. He makes so many charts for his courses. And I frequently will say, Karl, you don't have to make another chart on this topic. Please, because he's complaining to me. And he will say to me, Lucy, I have standards. That is what he says to me over and over. I have standards for my teaching. So I just wanted to let you know, he cares so much about his teaching that I get his complaints, but you get his wonderful teaching and his wonderful charts.
So, yes.
And I should have added along those lines that when I was a law clerk at Siegel-Reutemann, I worked in the library directly across the hall from Karl. So I would frequently see him in the morning making a list of all the cases that he had to do, and he would put a circle and a number in the left margin, and then write the name of the case and what he had to do, and then number 2 and number 3. And he would get up to like number 42 in his list, which impressed the hell out of me that he could keep track of all those things. And I can see why he decided he wanted to be a teacher instead of juggling all of those cases. And I felt the same way when I was a young labor lawyer. But to this day, when I'm trying to remember what to do in my day, I make a numbered list with a circle and then the number in it in the margin, and I owe it all to Karl.
Oh,
Yeah, sorry, I just wanted to say I'm Megan, I'm a 3L. And I'm mostly living under a rock because I didn't know about Karl when I decided to come to but I knew him 1 year because he was Lucy's friend, and I was lucky enough to talk to Lucy for civil procedure. And due to the pandemic, I only was able to have Karl virtually. But last year during my 2L year, I took 3 fully virtual classes with Karl, and they were all amazing. Highly recommend, obviously. But one of the first memories that I have is during labor law I took in the fall. He added extra work to his plate a few times, but one of them was like after the first class, our discussion of a case was going on, and he offered to write a memo for the class. He was like, please let me write you guys a memo, or I'll send an email clarifying. And I thought we were gonna get like a paragraph, like, hey, here's the answer to this. It was a multi-page memo with so many details and every explanation that you could ever want. And it was just such a testament to who you are as a professor and just how much you care about us, to Lucy's point. I'm so sorry, Lucy, you have to listen to him complain about this, but I can promise you, truly inspired like my entire year with you. And between the two of you, like the best law school professors and mentors that we could all ask for. So thank you so much.
and I will say, just on the subject of online classes, so Karl is many things, but I'm not sure that a technical whiz is one of them. And my office is right down the hall, and not that I'm really a technical whiz, but I seem to be the on-call tech support sometimes, like his phone or whatever, both Karl and Lucy, I'm right between them, and I get them both with all their. And I remember when we first went online very abruptly, right? Nobody knew what the hell they were doing. We didn't have Zoom even. We were on like Blackboard, I don't know what. And I remember kind of holding Karl's hand for his first class, getting him online and sort of making sure it all worked. He had no idea. And then I kind of tuned in 6 months later. He invited me to a movie night that he was doing for his students where he was showing labor films. And And, I tuned in on Zoom and there he is, and he's like sagging back and forth with the, the video and it's all working fine. And he's using the chat, and he really did get very good at it. So, he had a growth mindset about it. So yes.
I didn't graduate from Northeastern Law School. I went to Hofstra, but Karl was my teacher in political science classes at Adelphi University in 1969. And he was a new teacher. And I was basically a wet sort of person coming to learn about left politics. And Karl was my mentor. And he was a wonderful, wonderful mentor. He just sort of took me under his wing. And I've been friends with Karl for many, many years, through today, and we've been through a lot together. But mostly the thing that Karl is his passion and his love of teaching. And he's just such an extraordinary person. And I really love him beyond belief, because he's always there. He's a stalwart. If you have a problem, you can go to him. He doesn't always have the answer, but you can go to him. And one of the things that brings me to raise my voice here is the fact that Karl basically taught me the basic reader of Marxism. And I was wondering whether the comments today by, I'm sorry, I don't remember whether that was revisionist history. But, one little anecdote that I have is that Karl was always there, but when he felt a little insecure once in a while, he would look to his friends for help and assistance. And in 1970, at the height of the Vietnam War, we were in a small little school together at Adelphi University. And we needed to do something. We needed to do something stark and powerful. We get into the paper, and this group of us lefties at school decided we would stop the traffic on the Long Island Expressway with banners and rush hour at 8 o'clock in the morning. And Karl was worried about losing his job at Adelphi. We were all excited about it. And he egged us on. He was scared to death about going out there himself. So we let him sit in the car, but he had to drive. And so that was one of my initiations into the politics that I have now, and that Karl continues to have. And I'm just so lucky to be here listening to all of you.
After hearing a comment from the relatively new attorney at Siegel-Reuben about the phenomenon of duty of fair representation cases for union lawyers, I had to reflect, or have reflected, one of the great benefits of being in Karl's labor law class, because I had him for torts and then labor law, was the exploration of this dynamic between the collective and the individual. I had staked out personal positions. I had been a public non-registrant for the draft and was very active in the Philadelphia anti-draft and anti-war movement. So I sort of had embodied that individualist, you take a stand. To me, the Holocaust meant we had to make choices and we had to stand out. We couldn't just be silent. But then as I worked with the labor movement as a student and becoming a lawyer, the fact that we explored fully in my mind, beyond points I would have, I think, thought about, the tension that can emerge between an individual and his or her expectations of what will happen with regard to their rights in the workplace, and that union and the authority it has. I've had the opportunity to go to the Supreme Court with a case on behalf of a labor union contending with a very contentious member. It's a profound challenge and I've also seen some very difficult situations where the membership got to vote about a grievance. So you didn't have this insular level of officers who you typically could educate about what the DFR responsibility meant. And I was comfortable telling people, you have to seriously look at this, whatever it is. You have to think about it and make concrete decisions and then be prepared to back. But later in my career, I got very involved in representing individuals in employment discrimination matters. So I got involved with the employment lawyers community in DC. And they were like ships passing the night. Most of the lawyers that were representing, they couldn't fathom why I would represent a union. For them, like for too many people in the progressive left, unions became sort of bad figures. They weren't fully embracing something that they thought should have been embraced. And it became very difficult. I was often looked to sort of give small tutorials to both attorneys over what the union's position would or why it might be that. And particularly around the issue of whether an individual should be allowed to have their attorney involved in a union proceeding. And how difficult it was. And I think it reflects on how people aren't pushed to think hard about those things before they're in the midst of them. And again, I think it was coming earlier, Emily might have mentioned, most law schools abandoned labor law decades ago. It was like it was no longer necessary.
Yeah.
Because the dominant forces decided they weren't going to have anything to do with it. Well, we know they have to deal with it. And we can celebrate it's still happening, but I was so grateful when I confronted some of those that Karl had pushed us to think hard about.
Well, so I just want to bring this to a close here. This has been so wonderful to hear everybody's experiences, and I'm just reflecting a little on my own sort of what have I learned from Karl, and it's a long list. I couldn't go through all of it, but there's two things that I'm thinking about a lot today, partly because of all the things that have been said today that I've learned from Karl, and I think one of them is how to be a teacher, right? And how important it is to bring respect and care and humility into the classroom. It's been a kind of recurring theme today. And the other that I'm really struck by is sort of how important it is to forge these networks. It's kind of extraordinary to think about the networks of people, Karl, both his own networks and the networks he's fostered among other people. And I really think those are actually sort of two things, but it's really sort of the same thing, right? It's just being in community with people is really one of the things that you model for us very well. So thank you for that. And thank you to everybody. And we'll have a great
Yeah, that was a great
As a research practitioner, I feel like it really makes I love that Mark's got It is sitting in my book. Yes, exactly. She's not a person.
And if you don't want each other, but you can't handle these are the panels. You gotta add this. No.
How are you?
That was the first one I was like, yeah, somebody's coming. I always got first. I do want to say, like in terms of this, you know, this issue. When I came to these big chicken will be back. Who knows? She found that. He's back at the store.
I've met him a couple of times. I don't know him very well. I know that he's a law.
He's sort of a law.
We're trying, we're doing, so there's that. I don't know how they around the like in the same way that
I annotate additional comments.
Because so far she doesn't like really even make me everything. So we had a lot of I'm so sorry.
With the goal of people experience, as opposed to you're out.
We have like a red and a bunch of like chairs. Okay, everybody, we're gonna start the final panel of the day. All right, let's get back to it.
No, that's not the first one, but I mean,
All right, hi, everybody. My name is Libby Adler. I am fortunate to be a former student of Karl's, as well as now his colleague here at Northeastern for more than the last 20 years. Bringing us home today is a panel I've been kind of fantasizing about since the idea for this event was born. As you all know, Karl is a founder of and indispensable contributor to critical legal studies, as has already been mentioned a number of times today, which just made my own intellectual life possible. We're going to start with a video tribute from Professor Peter Gable, President and Professor of Law Emeritus at the New College of California, and Lisa Jakes, union organizer with Unite Here, a hotel and restaurant workers union. And then after the video, we've decided to proceed generationally. So we'll have the pleasure first of hearing from Liz Schneider, the Roselle Hoffer Professor of Law at Brooklyn Law School, followed by Jean Charn, Senior Lecturer on Law at Harvard Law School, both of whom I take it were here in the CLS heyday. Next, from one of, I think, the first generations of students he must be, to the CLS originals. Does that sound like about right? We'll hear from Nathaniel Berman, the Rachel Varnhagen Professor of International Affairs, Law and Modern Culture at Brown University, and finally, carrying the CLS banner into the future, including in her fabulous forthcoming book on the concept of risk in the HIV epidemic, Aziza Ahmed, Professor of Law at University of California at Irvine. So we'll start with the video. Thanks, Jacob.
Well, Karl, Lisa and I'm Peter Gable. This is Lisa Jakes. Lisa and I are so glad to be here to honor you on this celebratory occasion for being the wonderful human being that you are. and a great friend for many, many years. More than 40 years since we first got together trying to build the critical legal studies movement. And I have nothing but wonderful memories of being roommates with you at critical legal studies camp, strategizing with you about how to promote our line, and always have felt a tremendous admiration for the moral presence that you carry within you, the commitment to an egalitarian society, to a more humane and just world that motivates everything you do and everything you say. And that quality in you brings that out in all of us as well, all of us who know you. It strengthens our own conviction that such a world is possible, and it's a wonderful feeling to have that kind of affirmation of solidarity. And I guess I would say one more thing in this very short video, which is to honor the incredible contribution of your early work in getting critical legal studies off the ground. Because judicial de-radicalization of the Wagner Act and the origin of modern legal consciousness was a huge contribution to showing both that law in connection with a social movement can be a ground for advancing human ideals. In the case of the labor movement, in particular, the ideal of workplace democracy, solidarity, equality, true equality. And you also brilliantly showed how the federal courts, in the case of the Wagner Act, were able to absorb the energy of the movement, expand rights, and yet restrict their scope and application in such a way as to capture the movement's energy and form an ideology that ended up, to a large extent, justifying the status quo rather than fostering social transformation. So your work on how that process happens, how a concept of industrial peace can be constructed as important in a way that subordinates workplace democracy and other more significant social change. Your way of showing how that happened through a detailed analysis of cases had a tremendous impact on the critical legal studies worldview, its development of the idea of law as ideology and as a way of legitimizing an unjust status quo. So that double dimension of your work has been incredibly important to me and to the ability of our movement to get off the ground. So I just want to honor you for that early moment. I know you've done many, many things since then that are going to be discussed at this event, but you really made a tremendous difference in critical legal studies, becoming a movement that had wide appeal to people because of the hope that it offered for a better world. Lisa.
Yes, in addition to being Peter's partner, I am with the Hospitality Workers Union. And when I met Karl 30 some years ago, we were in a fight to organize a union at a non-union hotel where we had already launched a boycott. And the American Association of Law Schools was scheduled to use that hotel and violate our boycott. And Karl took the lead, along with a number of you in this conference today, or this event today. But Karl took the lead in helping us try to get the ALS to move out of that hotel. And although we weren't able to get ALS to move, a huge number of you, thanks in significant part to Karl, did move and did picket outside that hotel during that event, and did a number of other wonderfully agitational things during the event that helped lead us to victory soon thereafter in 1993 at that property. And then again, we were boycotting Hilton in San Francisco years later, and Karl again helped us try to move the ALS. Once again, we weren't able to move the whole organization, but a huge number of you stayed out of that property and picketed, and Karl led a speech and chants, I suspect, from a pickup truck outside that hotel. And I don't think a lot of professors do that sort of thing. So I just want to thank Karl for being my friend and my comrade and for helping my union. Have a wonderful day.
Thank you.
We love you, Karl.
We love you.
Okay, Liz and Jean, can I invite you guys back up? And Liz, I'll hand this to you. Thank you.
So I'm Liz Schneider, and I just have to say what an amazing day this has been to hear from so many people and to really see the breadth and the range of Karl's work in so many ways. I'm just thrilled to be invited to be part of this. I have known Karl since the mid-1970s and worked with him in a variety of different contexts, some of which I want to talk about, and talk about what I think are some of the dimensions that today's discussion and panels have really shown about him that just make him such an amazing and unique person and someone that I really love very much. So I think my first meeting, Karl and I were talking about it last night. I think my first meeting with Karl was on the stage at some event that lefty Harvard Law School students organized. And I don't know whether Karl was still a student then or he had started to teach here. I was working at that time at the Center for Constitutional Rights in New York. And I think it was a panel of sort of both activists and theorists. And Karl talked about critical legal studies, and I talked about my work at CCR with Arthur Kenoy and Rhonda Copeland and William Kunstler. And, you know, through schmoozing afterwards, I think we realized we both had been in SDS, and I heard him speak and I thought, this is it. This is the world I want to be part of. You know, it's like what Dan Danielson said at the introduction to Duncan's talk. It was like, this person is so clear about loving theory and loving activism and loving social movements. And at that point, I was on the verge of thinking about whether or not to move into legal academia. And it just had a huge impact on me. It really made me feel like if I moved into legal academia, I was already teaching as an adjunct with Rhonda Copeland at Brooklyn Law School, teaching women in the law. But the question was I going to really move? Was I going to leave CCR? Was I going to really move into legal academia? And I was engaged with legal, with CLS. I wrote a piece called The Dialectic of Rights and Politics that was very much tied in with sort of some perspectives about critical legal studies, and also engaged with a lot of other feminist work. And really, it was based on the work that I had been doing at CCR, which was in a range of different fields, but specifically on feminist legal work. And that's what that article really focused on. And it was around that time that there was a burgeoning of basically what developed as the femme crits. And some of the people that some of you may know, some of you may have been taught by them, Mary Jo Frug, who I also want to honor today with her passing in early April. Every early April, it's like another terrible wound. Mary Jo Frug, Martha Minow, Pat Williams, Zipporah Wiseman, Claire Dalton. And that was really a burgeoning group of people who did feel very strongly allied with the left critique in CLS, but also did not feel that critique had really developed a feminist perspective. During those years, I was a lot in Boston. I taught as a visitor at Harvard Law School from 1989 to 2003, teaching women in the law and battered women in the law. And so Femme Crits was something that was very much an ongoing part of my life. And I would always see Karl when I was in Boston. So Karl at that point, something that I think has not been mentioned, it's hard to imagine that there's anything about Karl's life that has not yet been mentioned today. But one of the things, Karl says, yeah, there are. But one of the things that Karl did at that point was he began to think about international connections. And so he organized a trip to Poland. And it was an amazing trip. Fred Block, who's here, was on that trip, and Duncan Kennedy was on that trip, and Mary Jo Frug was on that trip, and Pat Williams. And Karl was it was a trip to talk with colleagues, basically, lefty legal academics in Poland who had Poland had just, what can I say, become liberated, or that's what we thought. That's what we thought. And anyway, but the problem was that when we arrived at the meeting place where we were going to meet up first with our Polish colleagues, the first person I believe who walked out of the bus was Pat Williams. And Mary Jo Frug and I were sitting together. It just happened to be, I believe, Pat Williams. And she walks into the law firm of the Polish folks that we are meeting with and suddenly sees huge posters of Playboy nudes and other pornographic images. And Pat comes back into the bus.
That's a damn Saturday Night Live skit.
It is. And Pat comes into the bus and says, "Oh my God, we're in trouble." Well, I won't tell you the rest of the story, but I will say that it worked out actually to be quite an interesting trip with a lot of international dialogue, as was his usual. Karl was an amazing ambassador. And then I was thrilled and lucky enough when Karl and Dennis Davis got together to be then part of the delegations that were 2 delegations to South Africa to work on the constitutional transformation, which were amazing trips with Karl and Frank Michelman and many, many others that absolutely gave me, I mean, were so moving and so powerful. We learned so much from those experiences. They were totally, when I think back on all my work as a lawyer and as a legal academic, I mean, those 2 experiences were really among the highlights, and not so much, I mean, I think we had amazing conversations, but Karl's thoughtfulness about all of the different groups that were involved. I mean, think about what you are navigating. We are meeting with South African lawyers and activists, some of whom had been in hiding, some of whose, families had been killed. I mean, what did we know really to be able to talk about? And it was the process of it, the opportunity to share at a moment of such intense transformation was just an extraordinary moment. And I want to say Klare, Karl, and Frank Michelman, and Dennis Davis, who you heard from this morning, and so many of the other people who were involved made that really one of the most important really moments of my legal life. So back to FemCrits. One of the things that really was enormously important was that Karl had the ability to really understand that one way in which the FemCrits, and I can't really speak for everyone, but we had some shared views, that FemCrits really, because of our work on feminism, that we were really starting from the experiences of women. And we were moving to the theory which we were developing and wanted to develop in conjunction with CLS as a product, as a result of those experiences. Karl was amazing because of his experience as an activist and as someone who thought deeply about both activism and social movements and practice. He absolutely wanted to engage all of us and make us a part and have a feeling of solidarity and community within CLS for the burgeoning feminists who were developing, and to try, I mean, obviously he couldn't do this alone. I mean, there were many others who were very supportive, but he really wanted to keep us together as a community. And to me, this community was really for me, and I think for many of the other FemCrits, it was really their and our sense of community that we wanted to be part of. And I want to say that, although many of those people, have done different things now, or sadly, like Mary Jo, have passed away, there is still, I think, a lot of the resonance of FemCrit work that still exists. Many of you here, and believe me, thousands of law students around the country have been taught by people who were affiliated not only with CLS, but with FemCrits. And that the projects that have developed, which might not seem to be directly linked to CLS, for example, a project, Libby and I were talking about it at lunch, a project called the Feminist Judgments Project, which has taken the idea of having feminist law professors around the country in many different fields write new opinions for cases that were horribly decided. And that is an example of saying a different world is possible. And let us write that. And, that has been used in many classrooms. It's an example of a kind of legacy, third generational legacy, in a sense of FemCrits. Now, we're still asking, obviously, God knows today, with everything that's going on, we've not answered any of the fundamental questions about, how law matters, how it ties in with social movements. This is ongoing discussion. It will be ongoing discussion, I believe, for all of our lives. But I want to emphasize two things that I think have been overlooked as possible examples of where both CLS and FemCrits have made a difference. And it's very practical and may sound very boring and reformist to everyone here. But really sit down and think, whatever you may think of what has happened in the Biden administration, think about judicial appointments. Some of these folks, the first public defender on the Supreme Court, the first Black woman, so many legal services lawyers that have now been appointed to federal judiciary. Think about that, because they are people who very well, they didn't all have Karl, obviously, as their professor, but they may have had others because of the work that Karl, that we've been hearing about all day, the work that Karl has done, the networking, the organizing, the dimensions of so many people who have been affected. Some of those people I know some of those people who have been appointed for federal judges, and some of them were exposed to CLS or to FemCrit teaching. And, you know, when, you know, you just have to think of that as an incredible piece of what's going on now that really carries on the legacy. And the other thing I would say, also may sound boring, reformist, etc., judicial education. Now, I'm somebody I've worked with the National Association of Women Judges, some of the most radical organizing I have ever done. Federal judges, women judges, state judges. When you do judicial training, you really can make a huge difference. I've taught domestic violence because that's one of the fields that I have worked in so many times to organizations of state judges and federal judges, women judges, about domestic violence. And there is not a single one of these programs that I have ever done in which one or two or three of those judges did not come up to me afterwards and say, I just want to talk to you privately for a few minutes, if you don't mind. This is a problem very close to my heart, and I've experienced this, and I don't really know who else to talk to. So I say that just because I think, honestly, given what's been going on with January 6th and Ukraine and all of the other things, that it's very easy for us to think, what can I do? And I think there are things to do. But I want to go back to Karl and close with talking about him. One of the most amazing reasons why, and a number of people have said it, Dan and Vina in the earlier panel this morning, one of the reasons why Karl is the brilliant teacher, human being, organizer, is because he really, really values relationships. And he really is in touch. He knows what solidarity looks like. And it's not some abstract, as we've said before. It's very concrete. It's feeling comfortable in a space, a safe space, where you can talk about the things that are really on your mind. And he has really practiced that. He has really built huge networks. Think about all the networks we've heard about today, just today. And there are some I know we don't even know about. The international legal labor lawyers, the transformative constitutional. I mean, my God, the desire to build community, to build connection is just unstoppable. It's fantastic. And it is really what organizing means. And it is really what solidarity and community mean. So this really is a labor of love. It's a labor of love for all of us. A love of his ideas, of his humanity, of his connections, of his ability to want to reach out to others, to build organizations. I mean, CLS was a start. Look at these other connections that we're talking about today. So I'm just so thrilled to be here and to really be able to imagine through the many stories that we've heard today about really reinvigorating a sense of what might be possible. Thank you.
You were next.
All right, I'll be next. I'll be next. I can say that Karl had a big influence on my trajectory and my work in law from when I started law school to now, which has been quite a while. It was 73 was when I was hired to be dean for the clinical program at Harvard Law School, so a long time ago. But in terms of critical legal studies, I was with others, much better read in political and educated in political philosophy, all kinds of things. But I was very excited to be part of the group that I think founded critical legal studies and at Harvard Law School. I think that we get some credit for that. And it was helpful to me in a personal way because when I got to law school and had my first year classes, I was completely unprepared for the teaching methodology, for everything about it. No one in my family had been a lawyer. I didn't know anyone who'd gone to law school. And I could not figure out what the hell was going on in the class. The state the case stuff, like I would listen to what they did, but I didn't really quite know what it meant to state the case, then distinguish the case. What else could it mean? I was more at home then. I was pretty good in English, lit, things like that. But I really couldn't make much sense of it. Eventually, it looked to me like the practice in rationalizing judgments where there's appellate precedent, and maybe you want the outcome to be different than the precedent. It seemed to be a revered thing in law, a kind of cathected item. To me, it just seemed a demonstration that language is very elastic, that a statement can mean more than one thing. So I kind of got that, but how would you use that? What different? And it looked like, you use that and that's the way you get what your client wants to go in a different direction. And I was disappointed because I thought that law school was going to be about the larger social picture. What was government doing? What should they be doing? What laws would help? I was a 67 graduate at University of Michigan, started law school in 67. So we're right in the middle of that period in the 60s where more progressive legislation was signed than at any other single period in the history of the country. So I thought law was going to be all about that. And then I run into this state the case in class after class. And I was pretty disappointed and thought I might have made a wrong decision. And what the hell was I going to do now? I did have a scholarship at the law school in those days. Tuition at Harvard was $7,000 when I went, and I had a full scholarship. Just think about that. So I knew I wouldn't quit, but I didn't really at that time know anything about what being a lawyer might be or what this intellectual program was. And so time went by. I just thought I would have to swallow my disappointment and chug along, and then I'd figure out what to do afterwards. Initially thinking I'd probably go to a firm like everybody did, although that changed quickly, thanks to OEO, the Legal Services Program, and a program at Harvard Law School that after my first year, there were about 5 or 6 faculty who petitioned the Office of Economic Opportunity to start a poverty law program. And the demonstration project was, could law students make a contribution to getting legal services to people? So there were 4 or 5 faculty. I remember many of the names, but this was an OEO type program. It was not on campus. An office was opened in an apartment that had been empty down in the poorest neighborhood of Cambridge. And all of the criteria of the first OEO programs, maximum participation of the poor. So get in touch. There were tenant organizations. There was a lot of organizing at the time. So the clients were there. They were organized. And I started doing legal aid work. There were experienced lawyers who the grant had hired to supervise us. And so that resolved a lot about, I figured at least if I stuck with this, I would know something about practicing law. I'd learn some law, I'd know what it was, and I could probably get a job. And then it was after that, and I don't, Duncan probably knows the date, Karl does. I don't know where the meeting stopped, but this issue about critical legal studies came up. What if we did, if we made an intellectual exploration of the nature of law? I read it as nature of law and society. I was all for that. Sociology of law, the social sciences, where I thought what law would be about, anyway. And somewhere along the way, Duncan, there may be more people in the room. A thing came up about learning more about Marx's writing and thinking, and other faculty. I wasn't involved in the persuasion, but I signed up right away. Persuaded Karl to develop a learning program, a tutorial on a reading group. I think it was a reading group, and then we would have a discussion group, and we would have a discussion of the readings. And that went on for quite a while, a couple of years. And for me, it was, and I think for everyone in the group, but given what I didn't know about law practice, it solved a lot of things for me, because this is what I thought we'd be talking about. What's the role of law in society? It isn't, we're not talking physics, we're not talking chemistry. We're talking, how do we organize ourselves? How do we deal with different kinds of problems? Who benefits, who doesn't, all those things. And so political philosophy, sociology, all these things bear on that. And the Karl's organization of, I think we called it a Marxist study group, right? Yeah, Marxist study group. We weren't backing off anything. Ted Cruz, I hope he's not listening because he'll use this. And it was formative, I think, for all of us who started it or who participated, and it went on for several years. And more people around the law school, at the law school, joined, and so then you had more women. We had the issue of race came up, so there was both a femcrit and a race crit dimension to the project, and it was one of the most exciting learning experiences that I ever had. There was a lot to think about afterwards. In some ways, nothing was really solved, but the idea that you could explore these issues, discuss them, debate them in a setting where we're just trying to figure things out. And then I think it influenced everybody who participated in different ways. But it was like having a second shot at an educational experience. So that piece was central to everything that the opportunities that I had afterwards and that I did. By the time I was a 3L, I had so many cases at this legal aid office in the poorest neighborhood in Cambridge that they hired me as a supervisor. And then I started representing, Ed Brooke was the public housing programs around the country were New Deal programs, which means they it had existed in the 40s, 30s and 40s, and they were running down, they needed repairs. The rent formula was beginning to not fit. The New Deal program on public housing was that the government would do all the building, but the rent had to cover the operating costs. Well, in the 30s and 40s and maybe 50s, that was a pretty good formula, but it wasn't a good formula by the time you got to the 60s. There wasn't enough money. The rents had to go up and the buildings weren't in great shape. So there were a couple of organizers who came looking for me at the Klare, that was the name of the program, the Klare office. And it said, we hear you do housing work. And I said, yes, I do. And they said, okay, we've got a job. We want you to do this. And here's what we're going to do. Ed Brooke, who had just been elected senator, was on his way to being elected senator. Duncan reminded me today, a Black Republican senator from Massachusetts said he had a formula and he would get a bill passed that set rent at 1/3, at no higher than 1/3 of the tenant's income. So if you lived on AFDC and had almost no money, your rent, you could still afford public housing. And then they were going to get another bill that would send a lot of money to modernize, became the modernization program. And it all happened. It all happened. So I'm, legal aid lawyers are beating their heads against the wall now, but the experience at that time was I learned about a problem. There was a political support for the problem. The laws got passed. And then the issue was to simply make sure that the cities and towns who were using public house, who built public housing and had public housing, administered the program correctly. That's no simple thing in a place like Boston, because there was a lot of corruption. There were the political machine. There were categories of working on the city. You could get a job in an elevator at the port, turning the handle. These were old-fashioned elevators that would get you up to the floors, and you would just sit there all day. And if you didn't show up, someone would come in. There were no-show jobs. So part of the deal was if you had these resources that were supposed to benefit the poor, you had to see that they got there, and that the minimum amount had been doled out to the politicians who'd probably been promised something to vote for the bill. It was also the case that you could get a lot. You could get a lot through the housing system if you could get the housing authority to skip the waiting list. There was a waiting list for public housing. And if you could get your grandmother in to jump the list, then you could get one of these good jobs. And that was just Boston politics. So I had at the same time this theory and really kind of rigorous education in the critical legal services studies project. And I'm getting a street-wide how politics works in Boston. And at one point, I'd heard about someone who had done this. And I said, look, the biggest city that I'm around is Chicago. And in Chicago, if you did a favor like this, you'd get 3 times what you got here. So don't think that, Boston is so special. But that climate was and probably still is part of this work. So in the critical legal studies piece, I don't think without it that I would have ended up doing the legal services work and then staying and doing the legal services work. And because I did that, I was invited to interview for the job of assistant dean, the first dean for clinical programs. I did get the job, and let me just tell you this. I ran across a copy of the Harvard Law School record that had the announcement that I had been hired as this dean. So on the left column is my name, hired as first woman dean. And the column on the other side was Sachs denies gender discrimination. So there I am on the front of the record, an example of how there's less gender discrimination. Now, what the school wanted was women in tenure track positions, but this was an administrative position. Part of this is simply I think I would have stayed in law school because I'd started, and but if it hadn't been for the critical legal studies and the fact, the coincidence of that happening around the time that the legal services program in the country was beginning. This was the first government-funded legal services program that we had in the United States. So it's a little simple, but the takeaways for me over many years are a way of thinking in which you don't have to accept the way everything's structured as you find it. It really can be changed. It's not easy to change things, but they can be changed. Everybody knows in the United States that we don't have enough legal aid for everybody, and that we're different than every peer nation. Every peer nation has a guarantee of legal assistance for every low-income person who can't afford it, and some moderate income people with a small co-payment. So we're an outlier. We're an outlier in that area, and so the role of the ideas about legal aid in the United States have been shaped by that difference, and in many places, people just don't know that peer nations, Canada, the UK, all the Scandinavian countries have what they call a Judicare program. It's like Medicare. You're guaranteed legal aid, and the private bar provides it. Private bar can participate in the legal aid program. They have to accept the fees that the government sets, but there are plenty of reasons why solo small firm attorneys might take some legal aid cases now and then, just like in Medicare and Medicaid. The story, there are pieces of the story that I'm going to try to get down and put in an article before I leave the law school or this world. But we're stuck in the United States. The thing that we want is what the OEO Legal Services Program had: staffed programs devoted only to legal aid work, and we can't seem to. We're not going to get that, I don't think, not in the near future. And so the problem is that we need to think about other ways of doing things. And it brings me back to there must be a way to channel some of this stuff, to take a different approach. I think we should have a Judicare program, but the Judicare program reminds people of not getting the LSC program. So I don't know that's going to go very far. But there, some of the other possible, there are. I'm sorry, I lost. I should have made more notes. Anyway, there are ways that we can work at. We can work on doing some other approaches, and we're at another point where we're stuck on a model and can't move off of it. Is the point? And there's will to get the job done, but we need some more imagination and some more experiments to go to get any further with it. So the story is really a simple one. I got to law school. I didn't know what I was doing there, except that I got in, and I'd taken classes. I'd taken calculus and first year chemistry and gotten good grades because I thought about going to med school. And then I told my counselor that I fainted when I saw blood, and they advised me away from medicine, although I think if I'd been a man, they wouldn't have. And that's how I ended up in law school, found my way, and probably would not have stayed but for the people in this room who did critical legal studies and were mentors and partners and helped me along the way. So that's a story.
This is when I planned what I was going to do, I didn't realize I'd go just a half an hour before the end of a long day. So we've been talking about how wonderful Karl is for 7.5 hours. But we're going to do it some more now. Why not for another half hour, right? One thing I wanted to start off by saying is that I had this fear. I was thrilled when Libby wrote to me and said that this event was going to happen. Absolutely thrilled. And then I had this fear that people were going to talk about Karl as though he was over or dead or something, right? And I was thinking I wanted to give a talk that would be, I wanted to give a talk about him as an alive presence. And I'm going to talk about one of his early articles in a second. But I realized that the fear that I had was completely ridiculous, right? And totally absurd. Since this morning at 9:30, we've been hearing about how the Klare project is an ongoing project all over the fucking world. There are people who are engaged in the Klare project, including Karl himself, right? And they're on the screen and they're here and there and they're coming out of the woodwork. And what was I thinking even, right? That I had to do the counter eulogy, right? And what an alive and dynamic project the Karl, that would be a good name for a band, the Klare project. But it's really continuing here. So I should really just stop there, but I'm not going to. So what I thought I would do was to talk about the piece of Karl Klare's scholarship that most influenced me. As Libby kindly said, I'm the first generation. You said I'm the first generation of the Titans. Yeah, okay. First generation of students after the sort of the second tier. So when I went to law school, I thought this is a ridiculous, low-class intellectual thing. And I was really looking starved for intellectuality. I'd been a philosophy major in college, and I went to see Duncan, and I walk out of Duncan's office, like many people did in those days, with a stack of articles. You couldn't see my head anymore because the articles were stacked so high, and Duncan used to do that in the old days. So one of the articles that influenced me the most was Karl's article, Lawmaking as Praxis. And I haven't heard it mentioned all day long. And if you haven't read this article, it really is, you should do it tonight. It's a brilliant, really just a brilliant piece of writing. And it was, for me, it was directly related to what I've been doing as a philosophy student, I'd been spending thousands of hours reading Marx and Hegel in the Frankfurt School. And I read Karl's article and I thought, oh my God, here I am in this intellectual wasteland of law school. And I had no critical legal studies people in my first semester. We don't have to go into that, but and I thought, oh my God, this is just the next step, okay? And I wanted to talk about it for a minute. The thing I want to say about this article, I'm going to give an ad for the article. It's a classic. It's short, which is really great. It's short and it's a classic. And what I mean by a classic is it's something worth reading and rereading and rereading and rereading. And it takes on new meaning over the years every time you read it. That's what makes something a classic. So when the sort of thoughts triggered by some of the things that Frank was saying in that panel this morning, that our current situation is not between a stuck formalism legitimating the status quo versus a little pragmatism versus left-wing revolutionaryism. The right wing is not legitimating the status quo. They're on the march. You talk about transformative constitutionalism. They're not status quoizing. They're on the march. They're the revolution. The right-wing revolution is underway. We had it's really underway, and it's not going to stop yet. Maybe Justice Jackson will, with Sonia Sotomayor, maybe the two of them together. But it's on the march. So we're in a different situation, say, than it was when Karl wrote this article. It's a very, very different situation. And when I reread the article, I've now reread it 3 times in the last few weeks, it has a completely different feel to it than when I read it. I must have read it in 1982, right? But here's the thing about it, and here's more ad for the article. It's fresh. It's fresh. You read it and you feel like this is something that somebody wrote last week. It's fresh. And the reason it's fresh is because the ideas are alive, but it's also the content of the ideas, the particular ideas. So there have been some big allusions, sinister allusions to Karl as a Marxist that Duncan talked about. Now Gene raised the specter and we're going to shut down the recording so nobody knows. Right. But this article is just amazing. What Karl does in this article, if you haven't read it, it's his absolutely brilliant taking of a few of the lessons of the early Marx, the young Marx, the Marx of 1844, 1845, that period, and adapting them, understanding them, adapting them, modifying them, and infusing his understanding of law with them. It's just an astonishing thing. And actually, I know I'm only supposed to speak for 10 minutes, and I know you're supposed to leave at 5:30, but we're now going to have a 2-hour seminar. I know, I'll just stop for 10 minutes because I don't want to hog the time, but I'll just stop abruptly and brutally after 10 minutes. Okay, so just brilliant. And I want to start off with our panel is called Why Does Karl Start with a K? So I want to start with a quote from Karl. This is a quote from Karl. The coinciding of the changing of material conditions, on the one hand, and of human activity, distinctively human activity, in other words, self-transformation, on the other hand, can be conceived and rationally understood only as revolutionary praxis. That's from Karl Marx. It's the third thesis on Feuerbach, and Karl Klare's article, Lawmaking as Praxis, is a reading of the third thesis on Feuerbach in the context of law. The other thing from Marx is from the 1844 manuscripts, which Karl directly kicks in here, where Marx says, the alienation of the worker in his product means not only that his labor becomes an object, an external existence, but that it exists outside him independently as something alien to him. So this is the famous distinction, famous in certain restraint circles, between objectification and alienation. So Marx's thing is, to be human is to do stuff. I've never done any stuff. I'm just an ivory tower academic theorists, but I happen to be sitting next to some people who've really done stuff, right? And so being a human is to do stuff, to do stuff in the world with objects, with material stuff, right? And what happens under conditions of social inequality and oppression, and especially capitalism, is the things that you do then work against you. They become alien to you and they work against you. The worker in the factory produces a product, and the product then is used to oppress him, and so forth. So although it's the product of the worker's free human activity, it then is alien and it works against him. Okay, and so those two theses, right, that changing of material conditions and self-transformation coincide, and that they only coincide well when it's revolutionary praxis, right? And that distinction between objectification and alienation, those are the key ideas from Marx that Karl Klare takes and applies to law. And it's not just an application. It's a brilliant insight, something that German guy, Marx, he never would have thought of this. Maybe he would have, right? But the reason why does this article feel fresh? Here's why the article feels fresh. First of all, it's brilliant, but also because the idea is fresh. The idea is you're constantly transforming yourself. That's the idea. It's an idea that people usually associate with existentialism, but it's really Marx was there long before. It's the idea that in working in the world, you're transforming yourself, and that can either be done in conditions of freedom, in which case you're transforming yourself in an emancipatory way, or into conditions of oppression, in which case you're constantly reinforcing your own oppression through your activity in the world. And so what Karl says, so this is the thing about law, that lawmaking, and this must be after the death struggle between Duncan and Karl over Marx. This must be post that, right? Because Karl says lawmaking is good. And he cites a lot of E.P. Thompson here, right? That lawmaking is part of the way we run society, we run our human relationships. But under conditions of capitalism, it becomes alienated from us, and then those rules come back to oppress us. And it's that paradox. It's something that should be good, and yet it's alienated. So Karl says, E.P. Thompson is famous for saying the rule of law is an unequivocal human good, which was always a source of much merriment when I was a law student. And Karl says he's right and wrong. He's right, it's a good thing, but he's wrong because not now. Not now. And the thing is to transform it in a way that our activity as lawyers, as judges, legal theorists, and so forth, is no longer alienated from us, and then we can do it in freedom. It's just so brilliant. Jeez. And I have all kinds of quotes here. I'm not going to read all of them. So the judicial de-radicalization of the Wagner Act, which many of you have heard of, actually, it preceded this article. So this article that I'm talking about is really the theory of that article. Well, the theory is also in that article. The judicial de-radicalization is the example of the way in which objectification turns into alienation. The Wagner Act is, at least in part, the objectification, the turning into a out there in the world thing by workers' struggles. And yet, because of living in an alienated capitalist society, it then gets flipped around from being good objectification into bad alienation, something that then comes back and flips around to oppress the workers. Now, so I just want to do this end quickly here. I want to quote this from the article. I want to quote two things from this article. One is this: the fact that we must live and work within alien institutions that we do not control, which do not permit us collectively to guide our own destiny, ought not prevent us from conceiving of our own participation in the legal process to the extent possible as an experiment in the possibility of our freedom. It's a brilliant thing, isn't it? Right? So it's now starting from the condition of alienation. The fact that we live in conditions of alienation shouldn't prevent us from imagining what it would be like if we were doing all this damn legal work, but doing it under conditions of freedom. So it's, again, treating the creative activity, the truly human activity, which is creation in the world, now looking at as the law person, and the person who's out there creating the worker who is producing things, and yet their product is being taken away from them, and they're alienated and using to oppress them, and the worker is imagining what it would be like if I could produce for myself under conditions of freedom. And I want, I got to read one more thing and then I'll stop. Here's, I just love this. From page 127. And it doesn't sound like something Karl would write today. The conception of freedom as the material and institutional arrangements permitting human self-actualization and self-expression. So it's not just some politico. Human self-actualization and self-expression, and of human right as the right to community. Okay, we all recognize that. And communal control of the destiny of the species to work as a mode of self-expression. And then here's, I love this. Indeed, the right to the emancipation of the senses. He might be quoting Perry Anderson there. The emancipation of the senses. So there is, in this conception, Karl, who's deeply involved with fighting social injustice, right, is an unbelievable utopian, even messianic message here, looking towards the emancipation of the senses. I mean, in a way, that's a very 60s thing, but it's under conditions of freedom will be new people. And now I will read my last thing, which is that you read this article and it's an open-ended project, just like the Klare project today. And this is the last thing I'll read and then I'll stop. This is the last lines of this article. Karl says, I plead guilty. Oh, very Karl-like, I plead guilty. No, but listen to this. He says this, I plead guilty to the charge of raising issues today while providing little guidance towards their resolution. That's the humility, right? Meanwhile, he's provided all kinds of ideas, right? But I'm deeply committed to the necessity of the inquiry. It's the open-endedness of it. That's why this article, written 40-something years ago, feels like it was written yesterday by somebody who's 22, because of its open-endedness. And this is, I think, the Klare project today has that same feeling. Open, what's the next thing? And then he quotes Lukács. As Lukács once wrote, we must, quote, we must be able to comprehend the present as becoming. Only he who is willing and whose mission it is to create the future can see the present in its concrete truth. Keep on envisioning the future, Karl. You're wonderful.
Thank you so much. Thank you for that, Nathaniel. I'll just start by saying that I feel especially lucky to be on this panel. I know that there are numerous people at the Legal Academy, a list too long, they go far beyond the people in this room and on video, that would have had the opportunity to celebrate would have loved to have the opportunity to celebrate Karl's work, his legacy, and his kindness. And I know this because long before I came to appreciate the influence that Karl's work would have on my own understanding of the law was my experience of joining Karl Klare's faculty. When I joined Northeastern in 2010, there was not a single conference that I went to, this is not an exaggeration at all, in which someone did not say to me, oh, you're new to Northeastern? Do you know Karl Klare? And from those numerous people, I would hear things like, he saved my career. He wrote me the tenure letter that changed my academic fate. The university didn't like radicals. He supported me with my struggle at the university. And I continue to hear these comments even from my colleague at Irvine, who when he saw the schedule for this event said, you were so lucky to be able to work with Karl Klare. I once turned down a job that would have led me to Northeastern, and I always regretted losing the opportunity to learn directly for him. And it's true, I do feel very lucky. I'm not going to look at Karl or I'll get teary. So I have so much to say, but for my time, I'd like to focus in on a strand of Karl's work that I've latched onto because it resonates with me. And it's kind of similar, I think, actually, to what Nathaniel was saying now. But I'm referring to Karl's call, not so much with a specific outline or proposal for reform, but rather Karl's feeling in his work, one that emerges repeatedly for a world that can be different and better. I first picked up on this theme in Karl's work when I read his article, Transformative Constitutionalism, with apologies for repetition from this morning. And as I understood it, transformative constitutionalism is doing the work of adjudication in political and historical context, and with a vision towards achieving a country's political and social goals of a democratic, participatory, and an egalitarian direction. Karl makes explicit that for him, transformative constitutionalism is not a neutral concept, but one that is intended to connote a social good based on the assumption that egalitarian and social transformation is desirable. Though transformative constitutionalism was written in 1998, Karl's desire to write for a better world prevailed. The theme comes through as well in a 2015 article in the Stellenbosch Law Review, Self-Realization, Human Rights, and Separation of Powers, a democracy-seeking approach, in which Karl critiques the formalistic application of separation of powers discourse that he says is based on archaic spatial and territorial references that obscure the policy choices that judges make. Karl makes a call to see the idea of separation of powers moving towards a contribution to achieving fundamental values enshrined, in his case in the South African Constitution, before the project of nurturing human beings. And in 2020, in a recent blog post on the Law and Political Economy page, reproducing comments he made at the Jurisprudence of Distribution conference that as an organizer, I was told repeatedly blew everyone away, Karl makes his call more explicit. In writing about socialism and critical legal theory, Karl notes that Marx, despite his recognition that economics was constructed, was a legal formalist. Then Karl breaks from Marx's legal formalism, as critical legal scholars often do, to engage the law as indeterminate. To understand the transformative possibilities of law, we should understand the interrogation and contestation over legal rules and practices. And Karl offers what we can take from interrogating ideas of socialism, coupled with the indeterminacy critique. He says, our goal should be more caring and solidaristic forms of social coordination that will enable us to treat other humans as moral agents entitled to respect self-determination rather than just as means to satisfy our ends. This entails providing people with the socioeconomic conditions necessary to authentically experience self-realization. This is not simply a question of ameliorating material inequality, maldistribution, and absolute deprivation, but of confronting and undoing the power relations that generate and entrench them. When one engages with the scholar's work, as I have with Karl's, you meet it where you are at the time. When I first read Transformative Constitutionalism 12 years ago, I was in a moment of life transition. I was new to the legal academy and transitioning out of my career in international law and development. When I began working in the world of development with international NGOs in the UN, I entered thinking that there was something to believe in about rule of law style projects. How could I not? I learned my entire life, often in very explicit terms related to legal reform, that my family's own economic stability took generations and legal reforms to achieve. From being, this is our community history, we don't have that much personal family history, but from being untouchables and low caste Hindus generations ago, to our conversion to Islam, becoming migrants within India, moving with the masses of the urban Muslim poor, and immigrants in the United States. It was a success story of law and development. My father's elementary school education had been paid for by a development organization. None of his other siblings were educated. His home required sharing an outhouse with some other 30 or 40 people. Yeah, I've actually been there. It was donated by our religious community. An internal modernization project specific to our Shia sect that coupled with transformations in legal entitlements and around gender in India led to girls being educated, and an intra-community edict not to veil, controversially, and immigration reforms in the United States that drew South Asian medical professionals in droves. Something you could call law and development, legal reform or legal transformation was all over this. Colonial governance, title transfers, sewage regulations, laws on conversion in India, gender transformations, US immigration reform. Weren't we living proof that legal reform could work? But even as I entered international development, working and consulting with the UN and NGOs on issues of gender with the goal of continuing these legal reforms, so much of what I did bothered me. Even aside from feeling at times the absence of any sustained discussion on politics, context, and contingency uncomfortable, I couldn't sustain in myself the as-if way of being necessary to exist as an international development practitioner. How did so many people seem to believe that abstracted 10-point plans, let's say on enhancing capabilities through basic provisions coupled with formal legal reforms, without any real sustained understanding of context, would produce any predictable results. In the midst of my turnings, Karl's scholarship provided me a way forward. Given his characteristic humility, Karl did not propose to have an answer or a step-by-step approach to addressing the world's problems. Instead, as I read it, Karl's work makes room for the possibility of transformation while holding on to the idea that context and legal culture matters. He writes as a critique of the perception that old institutions can be replaced with new ones to bring social change. And this is Karl. Institutions, practices, and ways of life cannot simply be replaced. They must be reconstructed through countless, always provisional, local contestations. My first readings of Karl's work in 2010 stopped me in my tracks. Had I found it? A better way to hold on to something like hope and another world is possible while also believing in contingency and context? I wanted more. I read more Klare. I sent it to my friends. Vina didn't mention that I sent her the judicial radicalization article in 2010. Our ladies' nights are super fun. Followed by citations. I followed Karl's citations. I read more critical legal studies in general. And finally, I started to understand theory, which felt inscrutable to me. And I realized that I had a new way forward and a new way to understand our world. And I thank Karl for that. Outside of the specific context that Karl writes in, his work remains for me integral to understanding our current moment. One could mobilize Karl's idea in a million ways, but in my world of scholarship, which deals with gender and law and health, Karl's trenchant critique of the ideas of separation of powers provides one example. Many of us, of course, are watching the Supreme Court as they're about to overturn Roe, and then perhaps with it in the coming years, the entire line of cases in the context of substantive due process. Even as gains were made on abortion access with key cases like Whole Women's Health and June Medical, where the court deployed a separation of powers analysis, taking back the ability to decide on questions of whether certain abortion restrictions were necessary, that they painted as medical uncertainty from the legislature. And they said, yes, we can actually review these questions. And side note, finally acknowledging that poverty matters, that it can't be dismissed as it had in earlier jurisprudence. It's all being undone again. Chief Justice Roberts expertly deploys separation of power analysis to disable the perception that courts shouldn't have a role in helping people access healthcare, whether in the context of reproductive health or COVID. The stakes are high. While many scholars will theorize and debate these decisions, from my perspective, there is no plausible reading of these cases and their deployment of separation of powers, except for Karl's understanding that separation of powers disguises policy choices. And here he argues separation of powers is not a unitary or coherent doctrine or a set of values that may be brought to bear on legal problems. Separation of powers is a cluster of disparate and sometimes conflicting values that reflect the distinct and not always harmonious theories of democracy. As my students hold their heads in their hands as they struggle to find the right balance between their own faith and legal rules and politics, I find myself reciting Karl's ideas to them. Can we look beyond what is presented to us as unitary, coherent doctrine? Look beyond seeing rules as distinct from their context and legal cultures? Can we begin to imagine a different type of society that emerges from transformations in our own political and legal culture while we hold on to the idea of contingency? Can we hold on to the idea of a better future? I'm so grateful to Karl for his ideas, his tools, his kindness, his generosity, for letting people as I did fail in my attempts to understand and explain them again over and over. But most of all, I'm grateful to Karl for modeling for me and so many others how to be good in this world.
Thank you to these wonderful panelists for bringing us home here. I want to wrap us up for the day. We're going to give Karl an opportunity to talk, so that's why I'm not going to do this, even though you're instructing me to. But I want to first just give a few thank yous. The organizers wanted to thank Jacob Bouvier and Brad Whitmarsh for all the tech support. We want to thank Miel, Siobhan Fanning and Jennifer Giassi for all of the help planning and executing the whole plan here. After that, thanks to all the wonderful panelists who zoomed in or traveled here or did whatever you had to do to participate in the day. And let me say one more thing before I invite Karl up here. A few people have asked Jeremy and Lucy and me over the course of planning this, how we got Karl to agree to do this. And the answer is that we knew he wouldn't, so we did not give him the choice. You know, I assume the question comes from people being mindful of his sort of humble and self-effacing nature, and we were well aware of that. And so we went to his office and simply informed him that this was going to happen and that we would just contend with whatever confusing mix of gratitude and anger he felt toward us after that. So with that conclusion, I want to thank everyone again and invite Karl to come up here and cry in front of all of his friends and colleagues.
Well, I really am going to cry. So, it's overwhelming, your thoughts and feelings. And I'll do the best I can to get to through the next few minutes so that we can get to the drinks. I mostly want to give thanks and gratitude. I want to thank my colleagues, Libby, Jeremy, and Lucy for conceiving this day and organizing it so beautifully. They had the wisdom to scheme behind my back because I certainly would have put a stop to it. But I didn't know until it was too late. And even this traitor did not tell me. Again, a big shout out, please, everybody, for the people without whose hard work this never would have happened. So E.L. Marquis and Jennifer Giassi in Development and Alumni Affairs, Deborah Feldman, Siobhan Fanning in our Communications Department, and our intrepid tech geniuses, Brad Whitmarsh and Jacob Bouvier. Thanks to Thanks to Dean Hackney for his support, generosity, and leadership, and to all of the panelists for your energy and wonderful contributions. I should also say for somebody in my job, there is no greater honor than the recognition of the firms whose attorneys, including many NUSL graduates, daily fight on the front lines to protect and advance the rights of working people. And I'm humbled by the sponsorship of the 5 distinguished union side law firms that they provided for this event. Along my journey, I've had extraordinary mentors without whom I would never have become the educator or person I am, and I want to thank them. Duncan Kennedy, the intellectual giant and spiritual guru of the critical legal studies movement, devoted much of his life to modeling great mentorship. More than anyone else, he shaped me as a scholar and a teacher. In countless ways, Duncan also set an example of how to be an activist law professor, including his support for the Clerical and Technical Workers Union, for pay equity between professors and janitors, for rent control, for student protests, just to name a few. Duncan exemplified politicizing the classroom while delivering outstanding pedagogy. He has been a loyal friend, a go-to buddy through thick and thin. I give thanks for the great run that we've had causing good trouble together. Fred, where's Fred? Fred Block is my oldest friend and comrade, back to our days as Columbia undergraduates and members of SDS. We taught each other critical theory over a lifetime. Okay, we were nerds. Big excitement for us was when the latest issue of New Left Review showed up in the bookstore. But we kept up a vibrant and challenging conversation going on 60 years now about everything from the current political conjuncture to fundamental questions of method to intimate personal stuff. It is a fact, and I will say that undoubtedly Fred taught me more than I have. Through Fred, I met his partner and future wife, Carol Jaffe, a brilliant champion of reproductive rights, who has also become a lifelong intellectual companion and teacher. Two important mentors arrived later. Dennis Davis had no clue how he would change the course of my life and of my career by inviting me out to South Africa during the democratic transition in order to give a boring speech on American labor law. Dennis bravely defended democracy and racial justice during the dark days of apartheid. He was detained by the security police. And he went on to serve the New South Africa as a distinguished jurist and mentor to young lawyers and judges working to transform their country. He's been a wonderful teacher to me who has precipitated some of the most important and significant learning experiences I've ever had. I would never have written my South Africa articles without his guidance, encouragement, and partnership. And I've had the great fortune in life to cause good trouble with Dennis on several continents. I had taught at Northeastern for nearly 20 years before Lucy Williams joined our faculty. It's hard to imagine this place without her. Lucy's dad, a Baptist minister, braved death threats by preaching racial justice in East Texas in the 1950s. Lucy became a brilliant lawyer for poor people and victims of domestic violence, and later a gifted and beloved educator. She soon became another mentor and teacher to me and has been my steadfast partner in almost all of my projects in recent years, particularly Intel and ISERP that you heard discussed this morning. She's been a pal and an indispensable co-conspirator at Northeastern. She and her partner Faith were beloved friends to my partner Hallie. Legal education when I was a student at Harvard in the 1970s was repressive and dispiriting. I certainly would have quit had I not found and gravitated toward an extraordinary group of outsider professors. Besides Duncan, there was Gary Bello, whose name I want to mention today, Gene Charn, Morty Horowitz, Roberto Unger, and my beloved labor law professor, Bernard Dunow, who passed away during my 3L year. Under their spell, I germinated the wild and crazy idea that I could make a contribution to social justice by developing new forms of legal education aimed at training and empowering students to embark on careers as progressive and radical lawyers. I loved my years in labor practice, but in the end, I was unable to resist the call of academia. My most important expression of thanks today is for one of the great gifts of my life, Northeastern law students. I am so happy to see so many of you here today. Other law schools count on their faculty to attract students. It is a well-known fact about Northeastern that the faculty come and they stay here because of our students. You challenge us, you let us know when we need to do better. You want to learn to become social justice lawyers. Then you go out into the world and you do amazing things with lasting impacts and reverberations on the lives of so many people. Look around this room, and everywhere you will see people who work every day, rolling the stone up the hill to make the world a better place. If I can let myself think that I played even a tiny part indirectly in your achievements and impacts, I can go to my grave satisfied. So two concluding thoughts, please. Today, I thank you for enabling me to honor the memory of my parents, Mildred and Charlie Klare. I am grateful to them for teaching my brother, sister, and me about social justice and for setting us on the right path. My parents had a special gift which allowed them to show me the way while at the same time trusting me to find it for myself. It is not as though we agreed on everything. Normal adolescent rebellions occurred over such momentous questions as the validity of Trotsky's French turn in 1934 and whether Bob Dylan betrayed folk music in 1965 by going electric at Newport. My parents believed that people, these were their fundamentals. This is what I got from them, that people must have the courage of their convictions, that silence in the face of injustice is complicity, and then decent people stand up to injustice, solidarize with the victims, and find ways to resist. To the best of my ability, I've tried to live my life faithful to those teachings. And finally, today, I remember Hallie Carmen, my partner of nearly 35 years. I loved her for the wonderful, beautiful, brave person she was. And as relevant to today's proceedings, I loved her. And I'm grateful for this opportunity to thank her for trying her best to keep me true to our shared principles. Thank you for everything today. And now I want to invite everybody to the reception. It's downstairs where we had lunch. And come, let's have a glass.
Guy in the house? Yeah. Wow.
What's that?